If your organization lost control of 5 million payment card numbers, would you have suffered a data breach? Not necessarily, according to this very interesting new UK tribunal judgment against the ICO. I'll be looking at that case in this week's edition of the Privacy Corner. Also, the EDPB's new opinion about processors, sub-processors, sub-sub-processors, sub-sub-sub-sub-processors, and so on. And the CJEU, which has established, quite obviously, a commercial interest can be a legitimate interest. So first up, this UK tribunal case. This is from a long time ago. It's under the Data Protection Directive or the Data Protection Act 1998, but it's still relevant now. DSG is now known as CoEs. If you're in the UK, they sell TVs and stuff, and the ICO is the ICO. So this goes back to a data breach. As I said, 5 million payment cards were affected. Some of them had EMV protection, and in those cases, only the 16-digit long code at the front and the card expiry dates were stolen. Some of them did not have that protection, so the cardholder's name was protected as well. The ICO fined this company £500,000, which is the maximum at that time. The first tier tribunal cut that in half, but largely agreed on principle with the ICO. And the ICO's position, well, let's look at the DSG first, the controller. They said that where the EMV protected cards were stolen, the attackers didn't have the full name of the cardholders, so it wasn't personal data. So we can't be held responsible for failing to secure that data. In fact, we did by separating it out from the cardholder names. The Information Commissioner disagreed. They said that the EMV payment cards were personal data. The name is not relevant necessarily, or not determinative. The PAN code, the long 16-digit card number, is used to identify a bank account holder and is personal data in itself. So they got a big fine relating to all the different types of cards, not just those with the name linked. The First Tim Tribunal looked at this test from UK case law with 3 limbs for identifying personal data. Firstly, direct identification, limb 1. Secondly, data which identifies a living individual indirectly when combined with other information in possession of the controller. So in this case, the non-identifying personal data, the card number, is made identifiable because the controller has the card holder details. And the third limb is the same as the second one, but instead of the controller, it's a third party that either has or could come reasonably into possession of the additional data. So in this case, the hackers, as they are, as we might call them, just because they had the card numbers, they didn't necessarily have the card holder names. Would it be personal data if they did? How can we say whether or not they reasonably might have that data? Which limb is the relevant one here for this case? Limb 2 was the FTT's choice. They said that was most clearly applicable because even if the hackers didn't have the card holder names, DSG did, and therefore the long card number itself became personal data, whether it was in DSG's hands or the attackers. The upper tribunal takes a more nuanced approach, and they said the first tier tribunal should have looked at limb 3. So the cardholder number is in itself personal data if the hackers have it, if they don't have access to the additional information. They need to assess whether that was true or possible before they decide whether these card numbers were personal data from the perspective of the baddies. So this is quite important because it really narrows the scope of what personal data is. And we would be able to say in this case that merely by separating out the cardholder names and the cardholder details, the cardholder number, DSG took that cardholder number out of scope of the UK GDPR. And if you think about it, that's not just a security issue. There are other implications elsewhere in data protection law. I think this is probably a reasonably sensible conclusion, to be honest, from the perspective of those intruders. If they didn't have access to the name, perhaps they didn't have personal data. There are other obligations around cybersecurity and payment transaction data, the PSI, DSS or whatever. But we'll see how this one develops. It's going back to the lower tribunal now for reassessment under the upper tribunal's view. Next up, the EDPB has written an opinion. So they had two out actually yesterday. This one is about data processing agreements and processes and sub-processes and so on. So firstly, I would recommend, just a personal tip from me, always proofread your data protection agreements, your data processing agreements, before you send them to the other party. The EDPB has failed to proofread its opinion here before putting it on official EU websites, and there are lots of formatting and typo issues, but minor dig there from me. Several questions are dealt with here. I won't look at them all. Firstly, does the controller have to know the names or identities of not only the processor, not only its sub-processors, but their sub-processors, the sub-processors, etc.? Do they need to know the names of everyone in the chain? Well, probably yes. I mean, if we look at the transparency obligations, you need to be as concrete as possible when describing the recipients of people's personal data. It's not established whether those Article 13 and 14 provisions require the full list of names in the privacy notice, but they might. And nonetheless, Article 15 does. We know that if the data subject asks for the precise names of the recipients of their data, you do have to give them. So if that's your sub processor, then you need to tell the data subject who that is if they make an Article 15 data subject access request. And also Article 19 GDPR, you might need to pass on deletion and correction requests a long way down the chain. So in conclusion, yes, you do need a list of all your processes and sub-processes and so on. Processor needs to be very proactive in giving you that information, and they can do it in a format that the controller requests. Next, how far does the controller have to go to verify the sort of contracts and safeguards that are in place all the way down the chain, so the sub-processors and so on? Is that the controller's job, or can they rely on the processor to do it for them? Here it's a bit more nuanced. I mean, you do need to have some awareness of which controls are in place all the way down the chain. How much awareness, how far you need to go depends on the risk. So any level of risk, which is all DPAs, essentially, all data processing agreements, you do need some degree of due diligence. But in particularly risky cases, you might need to be doing audits or ordering audits of people all the way down the sub processor level. Next up, the decision to engage a sub processor always remains with the controller. So the EDPB is very keen to tie liability to the controller here. We get a slightly different approach emerging in the UK, I think, but we'll see how that goes. And the controller can request all sorts of information from the processor, including its DPAs with sub-processors. Next up, there's a bit of stuff on international transfers. Does the controller have to do an assessment for its processors' onward transfers? Answer is kind of no, but you do need very good oversight over what's happening down the chain. So the sub-processor obviously needs permission from the processor and ultimately from the controller to do an international data transfer. They must be able to verify that sub-processors are doing that right and they're providing sufficient guarantees, and DPAs might be checking this off the back of this opinion. Finally, sometimes in data processing agreements, we see a line that says the processor must obey the controller's instructions unless required to do so by law. Now, technically, that should be an EU or member state law, not any old law. What about these contracts that say law per se, implying that third country laws count? Are they legal? They're not illegal per se, according to the EDPB, but they are not encouraged because technically, according to this opinion, the processor could comply with a third country order requiring it to give up data against the controller's instructions, but they must not denigrate the level of protection offered by the GDPR. So that will require a case-by-case assessment to see whether the country's law is valid per se by the EU standards. So that can be really tricky and requires very careful mapping of where data goes from you to the sub-processor to the sub-processor, and so on. It's all about accountability, documentation, and careful due diligence. Lastly, the CJEU had I think 5 data protection cases on Friday. This is one of them, and it concerns legitimate interests. So in this case, a sports federation was sharing data about tennis players with sponsors. They were making money out of this. The tennis players weren't very happy, and the sports federation said it's in our legitimate interests. The Dutch DPA said no, it's not, and they fined them just over €500,000. And they said, which is their well-established permission, a purely commercial interest cannot be a legitimate interest. So you've probably heard about this position, this controversy, and the CJEU has now sorted it out. So according to the Dutch DPA, the legitimate interest has to be considered worthy of protection by EU law, and so it has to have some place in law. There's a positive criterion here, is what the court calls it. And this was not one of them. The Tennis Federation said that's not true. As long as it's lawful, it can be, in theory, a legitimate interest. It doesn't have to be written into the law that you can do this. It just has to be not written into a law that you can't. So the CJEU provides some discourse on the nature of legitimate interests in general and approaches this specific question. Does it have to be written into the law, or does it just have to be lawful? And the CJEU says that a commercial interest, as long as it's not unlawful, can be a legitimate interest, provided it's not contrary to the law. It can, in theory, be a legitimate interest. In this case, they are very skeptical about what this sports federation was doing, but nonetheless, if you're clear about it, you tell people what you're doing, and you give them the opportunity to request their data or object or whatever, then it can be legitimate in theory, as long as it's not outbalanced. There's a lot of very careful language here. It's not a free-for-all. They are just re-establishing what the GDPR says, and it doesn't say anything in there about a commercial interest not being legitimate. So this sports federation will probably not be terribly happy, but they did technically win this. It's just their specific circumstances might not have been legitimate. So that one's dealt with now. Big waste of time and money. Tells us what most of us already knew. Thanks very much for your time this session, and I will be back in 2 weeks. Thank you as always to Privado AI, and see you next time.